Welcome, everyone. Today we're walking through California Divorce with Children, the real world step by step version. This is a complete guide for pro se litigants, meaning you're representing yourself, but you're not doing this alone. Also, it's a guide for people who have attorneys and are still confused by the process because you do not want to pay your attorney to be your law professor or your therapist. So, what you'll learn today. Now, this is just the overview. It's not the specific classes with the step by step instructions, but this will give you a roadmap and it's very necessary for you to have this foundation. Today, you'll learn about the filing requirements, service, child custody issues, financial issues, court procedures, and final judgment. So, to start your case in California, you'll need the initial forms. They have the court required forms. So, some states do not require this, but California is one of the states that do. So, you'll start with your petition, which is Family Law FL 100, and then with the petition, you'll include a summons. And then you'll have to do what's called the UCCJEA declaration. Now, the UCCJEA is a very complicated law that's been adopted by the 50 states. For most, I believe Massachusetts has not adopted it. But essentially, what it does is it covers children and child custody issues when children have lived in several different states and there might be a jurisdictional issue. So, with this declaration, the Uniform Child Custody Jurisdiction and Enforcement Act. With the UCCJEA declaration, what you'll need to do is provide the address of where your child has lived for the past 5 years. So the court can determine if maybe another state would have jurisdiction over the child custody issues. And after you do that, you'll go to, if you need a fee waiver, you'll do the fee waiver form 001. So once you fill out the petition on their form, you will go to the courthouse where you will file the form. Some of the forms likely need to be notarized, and you'll visit the clerk and you'll pay the filing fee. If you cannot pay the filing fee, then that's when you will fill out the FW001. Serving your spouse. Now, this is extremely important, and it is not just a technicality because if service is not proper, your spouse can go through the entire process and come in at the end and have the entire thing thrown out. This is extremely important, and I cannot emphasize it enough. So, you'll need to do this through personal service, substituted service, service by mail with acknowledgement, meaning somebody has to sign for it. And proof of service will need to be filed with the court. You cannot hand the paperwork to your spouse yourself. You cannot mail it to them yourself. There's a very specific process that has to be followed to make sure this is done correctly. When you can't find your spouse, you can serve by publication. You'll need to say that you searched diligently and file an affidavit stating that. And this will be covered in our service class. And I will take you through the steps that you need to do to serve by publication if this becomes relevant for you because you cannot find your spouse to serve them personally. Now, if your spouse gets the paperwork and they do not respond, what will happen is that you'll get a divorce by default. California has certain forms you have to file with this, which is the FL 165, but you'll need to show that you served them properly in order to get the default divorce. And we will go through that in our answer and counterclaim course. Now, when they respond, and they don't agree with everything you're asking for, they don't want to give you the house or they don't want to give you custody of the children, then it becomes a contested case. This is a contested divorce. They might agree that they want a divorce and they don't want to deal with you anymore. But if they don't agree or you guys can't agree on even one of the issues, it becomes a contested divorce. So at around the 60-day mark, each of you will have to get your financial statements and your financial information in order and hand it to the other party. You do not serve that with the court. You do not give that to the court, but you will have to give it to the other party. And I would suggest when you initially file the case that you go ahead and you start requesting 10 years worth of bank statements and tax returns so that you or 3 years, I apologize, worth of tax returns and bank statements and credit card statements. So you are ready and you are not doing this at the last minute. So the mandatory financial disclosures, this is something that in a contested divorce that each party has to provide. You do the FL 140 form, which is the Declaration of Disclosures. You do your income and expenses form, which is the FL 150. You do the FL 142, which is the schedule of assets and debts. And then you'll do the proof of service that you gave this information to the other party. Now, after the mandatory disclosures, you or your attorney can do specific targeted discovery, which means interrogatories on FL 145, request to produce, special interrogatories. And all of this has to be done at least 30 days before the trial. This cannot be done last minute. You cannot be walking into court still trying to file your discovery demands. There has to be plenty of time for you to get the documents, for you to exchange it, and it to be reviewed. So during the divorce, this can go on for a while. So what you'll do is you'll use Form FL 300 to request a temporary order during the divorce. And what that will do is outline expectations of the parties as the divorce is pending. So that will give child custody and visitation, child support, alimony, who gets use of the marital house, things of that nature. So there's not a lot of fighting and disruption and chaos as the divorce is pending. You can also get emergency temporary orders, which is under FL 305, if there's an immediate danger, an immediate need for one. Mediation is required except in special circumstances. It's confidential. You can't use the information acquired against the other party. And you want to try to work things out at mediation if you can. You don't want a third party deciding the rest of your life if you can help it. So mediation is a good thing, even if you're not getting along. Try it. Do your best to make sure that there's not a third party stranger, i.e. the judge, deciding the rest of your life. Now, child custody for California, like every other state, uses the best interest of the child standard. So both courts want to ensure frequent contact with both parents unless there's a very good reason not to. So legal custody is the right to make major decisions about the child's education, and physical custody is who the child is with most of the time. So here's various schedules. You have the 2-2-3 schedule, where there 2 days on, 2 days off, alternating weeks, and then you have the old school every other weekend schedule. Child support in California, they have their calculators online, and we will have a link to that in our financial class. So look for that, but you can have deviations based on how much time you spend with the child. If the other party, the non-custodial party, makes a great deal of money, you can ask for a deviation based on high income. So we will go into that on the financial class, and we will refer you to the calculators for that. Now, if there's a temporary court order or a permanent court order, you can enforce that court order if it is not being followed. So FL 410, you can bring the other party to court for contempt if they're not picking up the child on time, if they're not dropping them off on time, if they're not paying temporary support. Enforce that order and set a precedent here that, this is how things are going to go. And this is, of really enforcing the court order and following the rule of law. Settlement versus trial. Now, if you settle at mediation, which is what we talked about a little bit earlier, you come to an agreement that you both can live with. That is the best way. If you can't do that, you go to trial and the judge decides disputed facts, and the rest of your life and the children's, at least until you can modify the order, is in the judge's hands. So you want to bring witnesses and evidence and things of that nature. So if you have to go to trial, you have to go to trial. But if you can settle it, that's always the best. The final judgment is on the form FL 180, and it is the final order of the court that you can enforce after that point. And at that point, any type of property division that's been ordered, you start going through that process and making sure the loose ends are tied up. Please comment in the comment section any questions or concerns about this course, anything that can be done differently. Now, this is just the overview class. Each specific course should go into the step-by-step process for things like service and mediation. But if it's not adequately covered, please comment on how we can do it differently and how we can make things clearer to make this as easy as possible for you guys. Thank you.